All right, I think it's about that time that we can go ahead and get started. Hello, everyone, and welcome to our Force Majeure webcast hosted by SVN, Saunders, Ralston, Dantzler, and Dean Mead law firm. My name's Tyler Davis. I'm a CPA and advisor with SVN in Lakeland, Florida. Joining me today from SVN is Gary Ralston. Gary's a wealth of knowledge on all things commercial real estate and is the most credentialed commercial real estate professional in the country. Gary will be speaking on the force majeure impacts between tenants and landlords. Gary, thanks for joining us today.
Thank you.
We're also very thankful to be joined by Tom Wirt, an attorney and shareholder with Dean Mead law firm. Tom is board certified in construction law and has practiced in real estate commercial litigation since 1993. Tom will be discussing the legal concept of force majeure. He'll provide commentary on Florida case law examples and how it might apply in today's COVID-19 commercial real estate market. Tom, thanks so much for joining us today.
Thank you. Glad to be here.
Thanks, Tom. We thank all of you for joining us today. We're very appreciative of the questions that have already been submitted. We've read through them, we've reviewed them, and we've tried to incorporate commentary addressing these issues into the presentation. However, if you still have questions, if the participants do, our contact info will be listed on the last slide of the presentation in case you have follow-up questions. Before we start, the first thing we wanted to do was do a quick polling question just to get a sense of who our audience is today. So you should see a polling question now. If you click on polls, it's very interactive. You can go and answer your response to the question, which is, what is your background or reason for joining the webinar today? The options are tenant, landlord, agent or broker, and then a real estate investor. So we'll give it a few minutes and let everybody respond before we move forward. And it looks like we have about 75% of responses recorded. And it looks like the majority of our audience today is landlords, with 47% of responders saying that they're a landlord, and then 31% saying they're a real estate investor. So we appreciate, again, all of you for attending, and that helps us think about how we want to convey some of the questions and issues that we're going to talk about today. So thanks again. A brief overview of what we're going to talk about today. We're going to talk about what is force majeure. Tom's going to give some introductory thoughts, a lot of background, force majeure in practice, some examples of Florida case law, and then again, how it might apply in today's world with COVID-19 existing. And then Gary Ralston's going to speak on the impact of COVID-19 and force majeure on landlords and tenants. So Tom, I'm going to turn it over to you.
Thanks,
Okay.
Tyler.
You should have access to move slides.
Let's see. Am I? Yeah, I can move the slides. Okay, great. Well, welcome everybody. As Tyler said, we're talking about force majeure here and related issues, related topics when it comes to commercial contracts. You've probably been hearing a lot about the concept of force majeure over the last month or so. Force majeure is the concept of excusing contractual performance as a result of unforeseen circumstances outside of the party's control to the contract. So many commercial contracts and leases contain force majeure clauses to allocate the risk of unforeseeable circumstances, and they provide notice provisions for giving notice if performance under contract is to be expended or excused entirely because of the event. So force majeure clauses traditionally encompassed extraordinary events identified as acts of God. The actual application of the term over the years has gotten a more wider and or narrower scope depending on the specific wording of your contractual provision. A force majeure clause is a contractual provision allocating the risk of loss if performance becomes impossible or impracticable, especially as a result of an event that the parties could not have anticipated or controlled. force majeure is French, and it literally means superior or irresistible force, an act of God. It is a narrow exception to the rule that contracting parties are bound to perform their obligations under the contract as they agreed, and if they don't, they have to pay damages for breach of contract. So this is a narrow exception that basically allows a party not to perform because of this unforeseen and uncontrollable event. So I guess the question is COVID-19, let's see. Hey, Tyler, I'm not being able to.
Okay, sorry about that. It says you have access. Let me see if we can move forward.
There we go. So the question is COVID-19 a force majeure event? And so I guess we need to go to the law of what constitutes a force majeure event. The concept has developed over time. Early on, a party's performance could only be excused if it was physically impossible. The concept then evolved over time from impossibility to frustration of purpose. In other words, if the contract is able to be performed, but the underlying purpose of the contract no longer exists, a party's performance may be excused. And then more recently, it has evolved into, the standard has become commercial impracticability, which means performance is still possible and the purpose of the contract can still be fulfilled, but due to changes in circumstances, the performance has become, and this is a quote, excessively and unreasonably difficult or expensive. So you'll see from the cases that doesn't mean just unprofitable. It means it has to be excessively or unreasonably unprofitable, which I think under the case law is a rare occasion. There's no uniform set of events that constitutes a force majeure event. Instead, force majeure clauses are flexible and they permit the parties to formulate an agreement to address their unique course of dealings and industry circumstances. So Tyler, if we could go on to the next slide. Let's talk about force majeure in practice. In determining whether a contracting party is excused from performance due to a force majeure event, a court will always start with the contract between the parties. It is very important that parties to commercial contracts sit down right now with their lawyers and review their contracts, because their rights and obligation will always start with the terms of the contract. If the contract is clear and unambiguous, a court will typically enforce it. And they will excuse the party's performance if it's clear from the contract that it should be excused. The key words there are clear and unambiguous, and depending on what the exact language of the contract clause, it may provide ambiguity where a court may do things differently depending on the circumstances. But if it's clear and unambiguous, a court can suspend performance during a force majeure event. They can grant an extension of time to perform due to a force majeure event, or to a lesser extent, they can reduce or eliminate damages resulting from a party's failure to perform. The best force majeure provisions are narrow enough to prevent the parties from misusing the contract to avoid the consequences of an unfavorable bargain, but broad enough to provide necessary relief if a material unforeseeable event does occur. Now, we're moving on. There are broad and narrow provisions. The benefit of a broad force majeure clause is it provides flexibility. For example, under the terms, the party's performance is generally excused with language like by act of God or causes beyond the party's control. The negative to this is it's difficult to predict how a court will interpret such clauses because they add ambiguity to the analysis. One judge's idea of what might be unanticipated or beyond the party's control could be quite different from another judge's interpretation. Also, if a force majeure clause is too broad, it may buffer a party against the normal risks of a contract. A force majeure clause that excuses a party from the consequences of the risk that the party assumed in the deal nullifies the central term of the contract, and a court will not enforce it to excuse a party's performance. We'll see a case about that later in the discussion. Narrow force majeure provisions provide a list of specific events that constitute a force majeure and typically state that it's not an exclusive list with language which says including without limitation to. So this provides clarity to the parties of what exactly will relieve the performance, but it may be difficult to anticipate all the possible events which could disrupt a contract. I've seen epidemics and pandemics in force majeure provisions over the years, but I wouldn't say they're common. Some of the federal government contracts, a lot of the federal government contracts include epidemics and pandemics in their language, but it's not generally in most force majeure provisions. Many courts are reluctant to apply force majeure relief to situations not listed in the narrowly drafted clause, even if the list says that it's not exclusive. For example, a 2019 Florida case stated, force majeure clauses are typically narrowly construed and, quote, will generally only excuse a party's performance if the event that caused the party's non-performance is specifically identified. Now let's talk about Florida case law. Although the cases in Florida are scarce, Florida courts have upheld force majeure clauses. For example, where the terms of developer's contract excuse the delay in performance for, quote, any other condition beyond the developer's control. Excessive rain, which caused delays in the developer's performance, was held to constitute such a condition excusing performance. In another case, a contractor's delay in construction of 9 homes was excused where the contractor's president suffered a heart attack, and the contract required construction to be completed in 6 months, but it said barring strikes, non-availability of materials, or other causes beyond control of the contractor. So that court basically determined that the contractor's president's heart attack was an event that was outside of the control of the contractor, and they were excused from delivering the homes late. In another case, a paper company was excused from paying liquidated damages, even though a design error delayed its compliance with an agreement with the Department of Environmental Regulation, because the error was outside of the company's control, and the contract provided that if a force majeure event occurred, liquidated damages would be mitigated. The definition of force majeure in that contract included, quote, other industrial disturbances not within the reasonable control of the company. And apparently the court in that case concluded that the design error constituted an other industrial disturbance not within the reasonable control of the paper company. So the damages against the paper company were reduced. Now let's move on to the next slide, Tyler. We're going to talk about Florida real estate contracts. This is the Florida Realtor and Florida Bar contract form, part of it, which includes a force majeure provision. As most of you are probably aware, this is a standard contract form used for real estate closings in Florida. And let's read the language of the force majeure provision. Buyer or seller shall not be required to perform any obligation under this contract or be liable to each other for damages so long as performance or non-performance of the obligation is delayed, caused, or prevented by force majeure. Force majeure means hurricanes, earthquakes, floods, fire, acts of God, unusual transportation delays, wars, insurrections, and acts of terrorism, in which by exercise of reasonable diligent effort, the non-performing party is unable in whole or in part to prevent or overcome. All time periods, including closing date, will be extended for the period that the force majeure prevents performance under this contract, provided, however, if such force majeure continues to prevent performance under this contract more than 14 days beyond closing date, then either party may terminate this contract by delivering written notice to the other, and the deposit shall be refunded to the buyer, thereby releasing buyer and seller from all further obligations under this contract. So this is what I would call a narrow provision. It lists out all the events that constitute force majeure. It does not include epidemics or pandemics. So based upon the case law, a court might be reluctant to excuse a party's performance due to COVID-19 under this clause, because the epidemics and pandemics are not on the list. Now, that said, there is a broad term on that list which says acts of God. Acts of God are reasonably unexpected events which are due directly and exclusively to natural causes without human intervention and which occur contemporaneously with the non-performance of the contract. An act of God implies an entire exclusion of human activity or agency from causing the loss or damage. So a party will not be excused if that party's own negligence or its failure to mitigate its damages was part of the cause. Courts have found certain events constitute acts of God, like violent hurricanes, floods, extreme tides, extraordinary snowstorms, earthquakes, and lightning. And then courts have found that other events do not constitute acts of God, such as heavy rain, which is merely unusual or unexpected, but not unprecedented. That's a quote from a Florida case, which I guess, again, it depends on the judge as to whether a hurricane constitutes a force majeure event or heavy rain, which is merely unusual or unexpected, but not unprecedented. But some of the other events that have been held not to constitute acts of God are settlement of soils, a boiler explosion, fires generally, and the sudden insanity of a railroad engineer. So again, it depends on the facts of the case as to whether it would constitute an act of God. So since COVID-19 seems to be reasonably unexpected, the last influenza pandemic was over a century ago, and it's a naturally occurring phenomenon, I would say it's an act of God. During the Great Influenza of 1918, Western Union Telegraph Company argued that a delay in the transmission of a telegraph message was due solely to the prevalence of an epidemic of influenza, which was an act of God. Some very old cases have held that epidemics are an act of God because disease must, unless under very exceptional circumstances, be viewed in law as the act of God. And again, those cases are from the late 1800s, so there's not a whole lot out there recently. Hold on, we're not ready to go there, Tyler. For COVID-19 to excuse performance under the Florida Realtors Florida Bar contract, a party's failure to perform must also be due directly and exclusively to the pandemic and must occur contemporaneously with the pandemic. The outcome in a particular case requires a court to conduct a fact-intensive analysis of the party's contractual expectations and the purported reason for the non-performance. The focus of the analysis is whether the risk or event at issue was foreseeable at the inception of the agreement and could have been subject of an express provision of the agreement. If knowledge of the facts making performance impossible were available to the promisor, he cannot invoke them as a defense to the performance. So a buyer under one of these Florida Realtors contracts may argue that government action brought on by COVID-19 was not foreseeable, and as a result, they cannot close the real estate transaction. But the U.S. Department of Homeland Security, in its guidance on the essential critical infrastructure workforce, identifies real estate services, including settlement services, which are closings, as essential. Also, a new virtual notary law, which went into effect in January, allows signatures to be notarized remotely. So there seems to be no reason why government action in reaction to COVID-19 would directly and exclusively stop real estate closings. Therefore, I think it'd be very difficult to argue that COVID-19 relieves a party from performing under a real estate contract. But again, it's going to depend every single time on the specific facts of a particular case. So now let's move on to commercial leases. A federal court in Florida recently evicted a tenant nursing home under a commercial lease because the tenant had failed to pay the landlord over $5 million in rent. The lease provided, tenant shall not be deemed to have committed an event of default if such event resulted from a force majeure event, which was defined to include government action or any other similar cause or circumstance which is not in the reasonable control of either party. The tenant argued that changes in government funding, which resulted in $7 million in lost revenue, constituted a force majeure event because it was government action that was not in the tenant's control. The court found that the tenant failed to prove that its failure to pay rent resulted from the government funding change as contemplated by the force majeure clause. The court relied on cases which have rejected force majeure arguments where government monetary policy simply made contracts unprofitable. For example, where deregulation of savings institutions resulted in an increase in interest rates and a slump in the timber market, where a collapse in world oil prices was caused by Saudi Arabia's government, and where government orders denied a utility company's request to pass increased coal prices along to customers. The court reasoned that a force majeure clause is not intended to buffer a party against lost profits, a normal risk of any commercial contract. So it seems clear that if the reason for non-performance is I'm going to lose money, that is not going to carry the day unless it is extreme. So there are cases outside of Florida that have excused performance under force majeure commercial lease provisions. For example, a landlord's obligations under a commercial lease at the destroyed World Trade Center was excused because a force majeure clause in the lease provided that the landlord would not be liable for any failure, delay, or interrupting in performance due to causes or conditions beyond the control of the landlord, which included acts of third parties. So the New York court held that claims by a tenant to recoup rent from the landlord because the building was destroyed were barred by the force majeure clause, which expressly excused the performance of the landlord under circumstances such as those presented by the 9/11 events. So in other words, the terrorists were third parties which destroyed the building, which basically relieved the landlord of any obligation under the lease, under the force majeure clause. But there's another 9/11 case where the economic impact of the terrorist attack on a conference scheduled at a Hawaiian resort did not allow the conference organizers to cancel the event under a force majeure provision. The contract expressly excused the parties' performance if acts of terrorism or any other emergency beyond the parties' control made it, quote, inadvisable to perform their obligations under the contract. Conference organizers claimed that cancellation was justified because the 9/11 terrorist attacks severely disrupted travel, decimated the tourism industry, and created a pervasive sense of fear that gripped the country, which made their performance, quote, inadvisable. The hotel countered that the actual reason the conference organizers canceled the event was because of the economic downturn, which, although due in part to 9/11, was too attenuated from the events of 9/11 to excuse performance under the force majeure clause. The court acknowledged that the force majeure clause did in fact contain the word inadvisable, but reasoned that the term had to be considered in context with the remainder of the clause, which entails unanticipated and uncontrollable events that render performance impossible or impracticable. Relying on cases which have held that non-performance dictated by economic hardship is not enough to make performance impracticable, the court concluded that force majeure clauses do not excuse performance for economic inadvisability, even when the economic conditions are the product of an unforeseen, uncontrollable force majeure event. So the court deemed the force majeure clause in this case as too broad and basically refused to enforce it because it took out the risks associated with the bargain that the parties made. So with COVID-19, a non-essential business tenant may argue that the executive orders issued by the governor closed its business and made it impossible for it to use the leased premises, and therefore it should not be required to pay rent for the time that the business was shuttered. But under the reasoning of this case that I just discussed and other cases, a tenant whose business is shut down due to COVID-19 will probably still be responsible for paying rent, even if the lease has a force majeure clause, because the tenant's circumstances could be seen as merely a financial hardship rather than making it impossible or impracticable to pay the rent. Since numerous cases have held that economic hardship from an unforeseen and uncontrollable event may not be enough to relieve a party's performance, I believe it will be very difficult to contend that a tenant's lost revenue from its business closure is more than simply a financial hardship that does not relieve the tenant of paying rent. I think that if non-essential businesses are allowed to open back up after a couple of months, they should be able to weather the financial hardship. And so that will also probably be seen as more of, an unprofitable or, bad economic situation for the tenant, and not making it impossible or impracticable to pay the rent. Let's move on to the next slide. So let's talk about construction contracts. And again, the construction industry is pressing forward. So we may not run into a lot of this going forward, because I think the construction industry is still moving on. But in the construction industry, most or a lot of contracts contain force majeure clauses, and they allow for an extension of time for completion of the project if certain conditions cause a delay in performance of the work that is beyond the contractor's control. To a lesser extent, the clauses also allow for an adjustment of compensation for excusable delays in performance. For example, the AIA A201 contract form clause provides, if the contractor is delayed at any time in commencement or progress of work by labor disputes, fire, unusual delay in deliveries, unavoidable casualties, adverse weather conditions which are unforeseen and abnormal, or other causes beyond the contractor's control, or by other causes that justify delay, then the contract time shall be extended for such reasonable time. That contract form also states expressly that it does not prohibit a claim for delay damages. So there is room in the AIA contract for additional compensation if a force majeure event occurs. Notice the broadening language in that provision, or other causes beyond the contractor's control, which expands the scope of the clause. As we've discussed, Florida courts have upheld such broad force majeure clauses. There are other provisions in commercial construction contracts, which will affect the rights of the parties concerning suspensions and delays caused by the COVID-19 crisis. Again, a thorough review of your contracts will set the stage for your available remedies if performance of a construction project is stopped, suspended, or delayed due to COVID-19. So what do you do if your contract does not include a force majeure provision? And Tyler, you can move on to the next slide. So if your contract does not include a force majeure provision, you need to consider whether there are certain defenses that still might apply to the situation. And these defenses are the doctrine of impossibility of performance, frustration of purpose, and commercial impracticability. Although these defenses have evolved over time and they have been used with increased liberality, Florida courts have held that these doctrines should be employed with great caution if the relevant business risk was foreseeable at the inception of the agreement and could have been the subject of an express provision of the agreement. Courts will not excuse a party from its contractual obligations simply because the contract turns out to be difficult or burdensome to perform. So impossibility of performance means it's totally impossible to do what was agreed in the contract. Frustration of purpose means, first, the event giving rise to the claim is totally unexpected and unforeseeable. Second, the risk of the event must not be provided for either by the language of the contract or by custom. And third, the performance of the contract must be impossible or commercially impracticable. Courts may relieve a party from performing a contract if any of these doctrines apply, but as with force majeure, courts are reluctant to excuse performance based upon impossibility or impracticability when performance is merely inconvenient, profitless, and inexpensive to the other party. An example of that is there's a Florida case where a commercial tenant of Publix signed a long-term lease, and over a 20-year period, the property taxes rose from $15,000 annually to $188,000 annually. The tenant claimed that the increased taxes created an incapacitating burden on it and frustrated the entire purpose of the lease, which was to make a profit. Therefore, the tenant contended that the doctrines of commercial frustration and impossibility released the tenant from the lease. The court was not persuaded. The court stated that since the property could still be used for rental, the purpose was not frustrated. And the court reasoned that feelings of financial frustration do not equate to findings of frustration of purpose or impossibility under the law. Again, the application of these doctrines is a very fact-specific inquiry. It completely depends on the specific circumstances of each case. In another case involving a commercial lease, an appliance store tenant had difficulty obtaining insurance, which was required under the lease. The court held that the tenant had not established impossibility because mere economic difficulty does not render the operation of an appliance store impossible. Regarding commercial frustration, the court reasoned that the difficulty obtaining insurance was a basic business risk that could reasonably have been foreseen by the appliance store at the time it negotiated the terms of the lease. In another example, in 2008, condominium purchasers brought a breach of contract action against a developer seeking to terminate purchase agreements because the developer did not complete their condo units within 2 years as required by contract. The developer asserted impossibility as a defense, contending a road permit was delayed by the 2004 hurricanes, which delayed construction of the condos. The federal court here in Orlando held that the impossibility defense failed as a matter of law because the hurricanes passed through Orlando an entire year before the parties executed the purchase agreement, and the resort was clearly aware of the risk of the road construction delay at the time it signed the purchase agreement. In other words, the delay was foreseeable because the event had already occurred before the contract was signed. The court reasoned it is not the function of the court to rewrite a contract or interfere with the freedom of contract or substitute its judgment for the judgment of the parties to relieve one of the parties from the hardship of a bad bargain. So now we move on to slide 12. So in closing, I expect that the COVID-19 crisis would be seen as an event which was totally unexpected, unforeseeable, and uncontrollable. In other words, a force majeure event. We haven't experienced a pandemic of this magnitude in over 100 years, but a party will only be excused under a force majeure clause if the language of the contract clearly and unambiguously relieves the party of performance. I also would not expect the pandemic itself would be seen as making it totally impossible or commercially impracticable for a buyer to close on a real estate transaction, for a tenant to pay its rent under a lease, or for a contractor to perform under a construction contract. Depending on the contract terms and the circumstances, suspensions and delays may very well occur, and I think performance could be excused for a short time depending on the circumstances. But I think in most cases, I would expect that performance would still be possible and not so, quote, excessively and unreasonably difficult or expensive as to be deemed impracticable. Non-essential business tenants may argue that their business closure makes it impossible to use the premises, so they shouldn't have to pay rent. But the cases hold that economic hardship from an unforeseen and uncontrollable event may not be enough to relieve a party's performance. A buyer may argue government action brought on by COVID-19 makes it impossible or commercially impracticable to close a real estate transaction. However, government action is not stopping real estate closings. Therefore, again, I think it'll be very difficult to argue that COVID-19 made it commercially impracticable to close. Since the application of these doctrines is a fact-specific analysis, the outcome of any dispute concerning these issues is going to depend on a judge's interpretation of the specific circumstances. And due to this unknown, the best alternative for most may be to analyze the contract and the specific facts of a dispute and try to work out a compromise with the other party. For example, suspension of rent or payment of arrearages over time, or a short delay in a closing date of a real estate transaction, those types of things. So that concludes my thoughts on the topic. When the time's appropriate, I'd be happy to respond to any questions anybody might have.
Thanks, Tom. We really appreciate you being a part of this and for your insight. That was very educational. And now I'd like to pass it over to Gary to discuss tenant-landlord implications. Hey, Gary, sorry, we just unmuted you.
Oh, good, yeah. There is a different impact on each property type, looking across the spectrum there. Retail. And retail is a barbell situation. Enclosed malls, and at the other end are retail shopping centers and freestanding. The issue is most enclosed malls today are closed. That triggers an interesting paradigm where maybe the landlord has some liability to the tenants because they may not have access to the space, etc. It is the industry perspective by most practitioners that enclosed malls as a property type may change forever on the backside as we come out of the COVID-19 issues. It's also generally agreed that strip centers and freestanding retail will recover quickly. People still need services. There still will be retail expenditures, which drives 70% of the economy. Much of that is being pent up. So we anticipate recoveries in the third and fourth quarter of this year and in 2021. Office buildings, they're generally open and operating. There's a lot of concern that this work from home arrangement that we see now is going to impact long-term office demand. But frankly, that's a little premature. There were several studies conducted before the crisis which indicate that traditional offices foster greater productivity and the ability to attract and retain the highest quality talent. So we believe that office buildings will survive and return. Multifamily, they're continuing to operate. The real issue is rent collection. It's presumed that about 30% of the apartment dwellers in the US didn't pay their April rent. Long-term, the demand between apartments and is highly correlated to household formation. So one of the things we expect to see is some consolidation in that area where the proverbial children move back home, reducing the demand, where people team up. We expect to see more and more kind of cooperative room rental situations, Airbnb on steroids. We expect very little impact on industrial. It should remain strong on both ends of the spectrum, both the warehouse distribution and also as businesses ramp up again in the recovery, we'll see smaller industrial being very much in demand. The hospitality or hotel sector clearly is a disaster, and it is really a different subject because it's not a multi-tenant platform. It's really more of a financing issue. What we're seeing today across the spectrum is most landlords are holding firm that the rent is due, particularly for tenants who are not closed. Let's go to the next slide. When we look at the lease, this is very much what Tom was talking about. So a few other slight perspectives here. The lease language is typically in favor of the landlord. As Tom said, the pandemic or epidemic, those are expressions which are rarely mentioned in leases. And the overall downturn in the economy really isn't applicable to say, well, because of that, I can't pay my rent. So it is an advantage for the landlord. There are some areas like closed malls where there is an impossibility of performance. If you can't get to your store, then you could make a case that you can't perform. That's the principle of quiet enjoyment, where which is in the lease typically, if the landlord doesn't provide access to the premises, then there may be an opportunity for the tenant to reject the lease, not pay rent, etc. You need to seek legal counsel for that. Another issue is co-tenancy, and where a particular tenant may be referenced in the lease. This is retail. They stop operating, they close, so perhaps that creates problems for the other tenants based on the lease where co-tenancy was specifically enumerated. Percentage rent, that's in addition to base rent, the tenant may be obligated in retail to pay some percentage of sales over a fixed amount. Well, if the store is closed and they're not doing business, that obviously is going to be an issue. That's good. Very good. Thank you. A couple of business industry survey issues. April rent collection. In the commercial space, about 2/3 of the tenants paid their April rent. About half of the tenants asked for some kind of rent deferral or abatement. And that typically was some sort of a trade, quid pro quo, an extension of the lease or the rent that wasn't paid or to be spread over a defined period the next 6 to 12 months. About 1/3 of the national tenants asked for some sort of rent deferral or abatement. Half the landlords said no to that request. And about half did some kind of deal, some deferral, the tenant would pay over time. And much of that is a consideration as to how the tenant's business would be impacted. Restaurants are a big component of that, as well as tenants that may be closed because of the stay-at-home orders. Only about 20% of landlords have sent default notice to non-paying tenants for April. About 3/4 of the landlords made their April mortgage payment. It's good to remember that about 15% of the landlords don't have a loan. And about half the landlords asked lender flexibility. They reached out to the lender and said, you know, can I get interest only? Can we do something to modify payments? And about half the lenders are working on some sort of flexibility or have already agreed to something. 60% of the people surveyed think that stay-at-home mandate will be lifted by the end of May. 2/3 believe that the general public will resume shopping and eating out within 4 to 6 weeks. Let's go to the next slide. What do we need to work on here? Well, landlord and tenants need to work together. They need to be reasonable. They are not partners, and tenants need to remember that landlords still have a mortgage to pay. So they can't just say, we're not going to pay the rent, not provide the landlord with the income stream to handle the mortgage payments and expect them to deal with it together. The key element, working together and being reasonable. There is a government-sponsored program for commercial mortgage relief as a component of the PPP program indirectly, where lease payments can be considered part of what is forgiven through that program. So that may help a little bit with 60 days for tenants to be able to have some additional capital through forgiveness from the government, which they can use to pay rent. There may also be business disruption insurance. And so many tenants have that in their, as part of their program for insurance package, and they need to look at how that would work. And we mentioned the government-sponsored programs. That's really other things in the stimulus package, PPP and others, that could help the tenants pay costs and expenses. There's some special SBA loan programs they can apply for. One of the keys is tenants should not think that rent is their least priority. If they don't have the premises to be able to occupy, it's very difficult to conduct business. So it should be high up on the list of what to do. What can we expect in the future? Good news. Almost everybody thinks that Starbucks may lead the recovery. People will miss out on the small luxury that Starbucks provides. And in addition to continued drive-through that we see today working well, they may lead people getting back out into open spaces. Apparel may struggle. Feel-good apparel will be the best performer. We anticipate there being a real run on pajama bottoms across the board. Tourism. Look at the recovery after 9/11 as an example. That's kind of what we could expect today. And we believe that although the circumstances are different, we should see a bounce back. We think that people are tired of stay at home already. They want to get out. And so tourism will recover sooner than later in the bounce back provision. Let's go to the next slide. Thank you. Thank you very much, Tyler.
Gary and Tom, thank you again so much for being a part of this. Thanks to everybody for watching and for submitting questions. We'll try to get those questions to either Gary or Tom so they can respond to you after this webcast is over. If you have further questions, here's our contact information. Feel free to shoot us an email. We'd be happy to help you. Also, please visit our website, svnsaunders.com/coronavirus. We are actively putting information online. We're recording all of these webcasts, as well as posting the slides and the recorded webcast online. We have another webcast this Thursday at 2 p.m., which will be linked and marketed on that website as well. So we look forward to you joining us moving forward on more of these webcasts. And thanks again for joining us, and we hope you have a great rest of your day.